after say EC e declare 7 seats e dey my NPP no NDC so tabiri asem no de kwada e Supreme Court so Supreme Court onhwe nsem no omo kan nsem ni yie enfa ma omo enra e wo e Supreme Court abusia Supreme Court e judges no e ka say sa 7 seats no declare dey my NPP no omo je mu 4 because omo say 4 na omo kan dey basabasa e bia nkoso we nsem e koso ewo eye Supreme Court enra na enra ewo Supreme Court ho no lawyer wo gina asem ni mu e de ma NDC expose eye judge a what na asem no so first ewo eye High Court before say regulations ensem na e be do Supreme Court no dey ka ko High Court nti High Court honom no e na munya atumi say easy enquire regulation ti regulation ni mu no e ma NPP enya eye 7 seats enti ewo Supreme Court honom no lawyer wo gina asem ni e de ma NDC no o ka kire eye Supreme Court judges ne say omko High Court no or presenting a video evidence e de ma High Court judge nemum no High Court judge ni ka say enya de obehwe video no enti ono de any ruling e na ode ba na ode ruling ba ya e ma EC e declare 7 seats e de ma NPP ka asem ni wie no e na Supreme Court judges no e ka say sa e na course de a e ne nsem no omo je e de free e High Court judge ni nsem e de ma judge for we ni o ma course so e wo e Supreme Court enra na busuam so obeje de say omo yo madwe say omo wi ankonya no e de ma NPP no ma me fa nsem we ma mehiem se na be yo beti ase kai say me ka kire wo say lawyer na wo gina asem ni mu e de ma NDC no o ka kire e Supreme Court judges ne say o present video evidence e de ma High Court judge no but High Court judge ne na adwen say wonti sa ne woni pepepe e na to EC chairperson time okoye interview e wo TV3 e ma host no e bisa ne say de ba de e na wo gina aso nti omo sade ye regulation no e ma chairperson na ye friend e bossman asare no e ka che TV3 TV host no e say basa ye e koso e ma host ne ka say there be ye cameras wo ho no nyina ye hu se basa say ye bia koso but bossman asare e say there be chinchina basa ye koso na kire say obeso beje nsem a TV3 host no e kan e kire ne sada na e wo interview no so
what you just read you said the return of some must put together all the polling station
yes, but
results.
I'm arriving at a result. I'm just saying that after you have declared the winner, I didn't see anything in the CI that said that after declaration is done, you go back and say that because there were these previous challenges, we are going to redeclare winner.
No, but let me say this. We have officers, returning officers for each constituency. The same people who declared the results you are claiming they declared said no, that's not what transpired. And that at a gunpoint, at a knife point, I was compelled to declare a winner who didn't win.
Our cameras were there. I don't remember we reporting that they put knives and guns on the head.
Did you watch the declaration of Okankwe Central? Have you seen the footage?
I did.
Did you hear the officer saying I declared with 78%?
No, but
did you hear that?
I'm asking you a question specific to what you just said, which is the guns and the knives, and I'm saying that I don't recall our cameras recording that.
But usually in those
because that's what you're using to say under duress.
No, the point is under duress. Apart from that, but did you see the footage of Okankwe Central being declared?
So pepe and a High Court judge no so because time NDC lawyer no presenting case no and I say video evidence e chair a High Court judge no instead of say High Court judge no ebeje nsem no anaso beje video no ahwe ehun se basabasa ya nkoso no wotena ho kase onhwe video no but still now the ruling ba say EC enkoye recollation nti recollation mu no ene ma EC e declare 7 seats e de ma ye MPP na busuya me person kase bebre no yenti nioma e course e wo eye Supreme Court after say NDC lawyer no expose eye NPP judge now no wote asem no so e wo eye High Court ha say malikbasintale TV so we and first number channel so more than subscribe share no be video ni bi enhwe
telling how an originating process should be done differently other than order 4 is applicable. And my lord, if you look at the reasoning of the trial judge, yes, he did not reason that the application was brought pursuant to order 4. For which reason he was not going to hear it.
I haven't said that.
So I'm just pointing out.
I was asking whether, given that Order 55 has prescribed the means by which the court may hear a party whose interest will be affected, there is a need to even call in Order 4, and whether Order 4 has legal basis.
My lord, a quick
in a judicial review application.
My lord, we notice that the issue of natural justice,
yes,
is a constitutional matter.
Yes.
And the rule cannot, as it were, defeat the intent of the Constitution. that to the extent that a person will be affected by a judicial decision, that person ought to be heard, with or without the rule. And so the issue of the rule coming in aid with the greatest respect does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. 2. Yes, proceed. In addition, my Lord, even without Order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
How, in what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for Mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition,
yes,
and then the statement of case in opposition.
Very well.
Address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review application. Why judicial review application? My Lords, exhibit attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission Respondent, National Democratic Congress. My Lord, it's in the supplement. Yes, so my Lord, I'll be very specific. I have a supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other I have it as A or C. Is the problem you have created for us?
My Lord, I'm sorry. I'm sorry about that.
Unlike the other parties who have actually flagged.
My Lord, that should be exhibit D in our supplement.
D.
Is the application for judicial review by the NDC. So this one is the application.
Yes, you make the point and let's see if it will help us locate.
Okay, okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This Mandamus application was filed on the 17th. But my Lord chose to hear the Mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And he was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. That, my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes, Council.
You see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context.
Okay.
The process he filed.
Counsel, you can read.
No, just hold on.
Please. What he filed was not before the judge. It was not before the judge.
No, it may not be on that docket.
Was listed.
It may not be on that docket, but it may be in a separate docket.
No, he came to court holding the documents.
No, we're talking about the second application. Or the first application, the one they filed on 6.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
Yes.
continue.
So, my Lord, at the time, my Lord considered he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the Mandamus application, he now asked me to call that.
Oh, okay. So he heard it.
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he would do it and started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the Mandamus. He knew that that would definitely affect their rights. My Lord, on the grounds on the grounds of bias, my Lord, the point we make here is that at the time, with respect, my Lord was considering the Mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest